This is Barry Zalma, Zalma on Insurance. In a recent decision of the United States District Court District of Utah, it became clear that a lawyer should know better and never lie on an insurance application. Because when a lawyer lies on an application for malpractice insurance, the policy can probably be rescinded and he would have no insurance at all. Travelers Insurance issued a lawyer's professional liability insurance policy to Grimmer Davis, Ravelli, and Balliff, the Grimmer Davis firm, which is a law firm with its principal place of business in Lehi, Utah. Matthew Grimmer was the sole shareholder of Grimmer Davis and had general managing and governing responsibilities at the firm. Grimmer is a licensed attorney with knowledge of the rules of professional conduct. Jacob Davis was an employee of Grimmer Davis. Davis is also an attorney with knowledge of the rules of professional conduct. Defendant Grimmer and Associates, P.C., G&A, is a law firm with its principal place of business also in Lehi, Utah. G&A is located in the same office as Grimmer Davis. Grimmer is the sole shareholder of G&A, and Davis was also employed at G&A. Grimmer made false statements in the application, and in a case called Travelers Casualty and Surety versus Grimmer Davis, the travelers sought to rescind the policy and an order of the court affirming its rescission. The background of the case involved the fact that a woman by the name of Georgia Noel Inman and her twin brother, Walker Patterson Inman III, were clients of or former clients of G&A and its attorneys. Patterson was also a client or former client of Grimmer Davis and its attorneys. Georgia and Patterson's father died when they were 12 years old. Their stepmother served as their deceased father's personal representative and successor trustee. However, there were allegations that she was pilfering or hiding assets from the estate. In 2013, Grimmer and G&A began representing Georgia and Patterson in the probate dispute with their stepmother in an action in Wyoming. On June 27, 2018, Georgia filed a motion to disqualify the firm Grimmer Davis and the individual attorneys Grimmer and Davis from representing Patterson in the consolidated trust cases pending in Wyoming, citing various conflicts of interest and breaches of professional duties against Grimmer Davis, G&A, and Grimmer Davis. In this disqualification motion, Georgia asserted that the Grimmer parties advocated for positions that favored Patterson and were adverse to her interests. The motion stated that Georgia potentially has claims against parties and lawyers in this litigation, and Georgia now has viable claims, which she will be bringing to undo both the Greenfield Plantation sale and the assignment of claims, two transactions involving Georgia, Patterson, and Grimmer. The Wyoming court appointed a special master in the consolidated trust cases who issued a report of special master on Georgia's motion to disqualify on March 5, 2019. The special master found that Grimmer made an audio recording of Georgia and used her confidential statement to him in a manner adverse to her best interests. Finally, the special master found that in refusing to pay sums due for the purchase of the Greenfield Plantation and in filing a counterclaim in related litigation in South Carolina, Grimmer was adverse to Georgia. The special master recommended that Grimmer and Davis be disqualified from further representation in the consolidated trust cases, and that any member of any firm with which Grimmer was associated also be disqualified. He further recommended that Grimmer's pro hac vice admission be revoked. The South Carolina court also found that a material adversity existed between Grimmer, who at that time was the trustee of a trust holding assets for Patterson as the sole beneficiary, Patterson, and Georgia. Now, Travelers had initially provided professional liability insurance coverage to Grimmer Davis for a policy period from March 20, 2018 to 2019. At the conclusion of that policy period, Grimmer Davis failed to submit a renewal application, and the 2018 policy expired, a claims-made policy. Travelers did not automatically renew Grimmer Davis's coverage. However, in April of 2019, Grimmer Davis requested that Travelers issue a new policy to provide coverage retroactive to March 20, 2019, the 2018 policy's expiration date. Grimmer Davis submitted an application for insurance, which Grimmer signed on behalf of Grimmer Davis. In response to question 27 on the application asking whether, quote, you or any member or employee of your firm have knowledge of any incident, act, error, or omission that is or could be the basis of a claim under this proposed professional liability policy, close quote, Grimmer Davis answered no. Grimmer also agreed to immediately inform Travelers if any of the information supplied in the application changed between the date of the application and the effective date of any insurance policy. Travelers issued in response to the application. If Grimmer provided any changed information, the application allowed Travelers to withdraw or modify any outstanding quotation or agreement to bind coverage, close quote. In order to evaluate Grimmer Davis's request for a renewal policy with a retroactive effective date of March 20, 2019, Travelers required Grimmer Davis to provide a letter confirming that its attorneys were not aware of any facts or circumstances after March 20, 2019 that may give rise to a claim under the renewal policy. Grimmer Davis provided Travelers with a letter dated April 18, 2019, the No Known Circumstances letter, stating in part that as of the date of this letter, we are not aware of any facts, circumstances, or losses from the period of March 20, 2019 to the present as respects our lawyers' professional lawyers' liability insurance. Kristen Montalvo, the Travelers' underwriter responsible for the Grimmer Davis's account, reviewed the application and the letter to evaluate the risk of insuring Grimmer Davis. She provided Grimmer Davis with a quote, and Grimmer Davis accepted. On April 19, 2019, Travelers issued to Grimmer Davis a Travelers First Choice Plus Lawyers Professional Liability Coverage Insurance Policy, effective March 20, 2019 to 2020. A week later, coincidentally, on April 25, 2019, Georgia asserted a malpractice claim against Grimmer Davis, G&A, Grimmer, and Davis based on their prior representation of her. Montalvo, Travelers' underwriter, testified in an affidavit that if Grimmer Davis had disclosed Georgia's various claims and assertions against the Grimmer attorneys in the Wyoming and South Carolina actions as well as those courts' findings regarding ethical violations, Travelers would not have issued the policy. As time went on, Travelers filed a motion for summary judgment. Utah law provides for rescission of insurance policies in 3 circumstances. This is Utah Code Annotated Section 31A-21-105, parentheses 2, close paren, which governs rescission and provides that no misrepresentation affects the insurer's obligation under the policy unless A, the insurer relies on it and is either material or is made with intent to deceive, or B, the fact misrepresented or falsely warranted contributed to the loss. Courts applying this statute have held that an insurer may rescind a policy where 1, the insurer relies on material misrepresentation made by the applicant, 2, the insurer relies on a misrepresentation that was made by the applicant with the intent to deceive, or 3, the applicant's misrepresentation contributes to the loss. An insurer need only satisfy one of the justifications for rescission to rescind a policy. Travelers, however, claimed that it is entitled to rescind the policy under all 3 of those justifications. Grimmer acted on behalf of Davis Grimmer and attested in the application and the no known circumstances letter that no one at the firm was aware of any facts, circumstances, or losses that could impact coverage under the policy. However, at the time Grimmer signed these documents, Georgia Inman had already repeatedly threatened substantial claims against the firm and its attorneys, and 2 courts had already determined that the attorney's conduct was improper and breached professional obligations to a former client. The information Grimmer gave, or failed to give, Travelers occurred before Travelers agreed to issue the policy. Although the policy's inception date was backdated to predate the application, Travelers only agreed to backdate the policy because of Grimmer's misrepresentations and material omissions. The inception date of the policy, which was obtained as a direct result of misrepresentation and material omissions, does not require that the terms of the policy apply to the issue. The more applicable law in this situation is Utah's rescission statute. Utah courts have recognized that the doctrine of equitable estoppel will prevent a party from taking advantage of misrepresentations made in the insurance context. Equitable estoppel may be invoked to prevent injustice where one has reasonably relied to his or her detriment on an intentional or negligent false representation by another. All the elements for equitable estoppel are met in this case. Grimmer made untrue statements and omitted material information to obtain a policy with a backdated inception date. Travelers relied on those misrepresentations and agreed to issue the policy with the backdated inception date. The undisputed evidence demonstrated that Grimmer knew or should have known that the information he provided to Travelers was false and given with the intent to obtain an insurance policy. Intent to deceive can be inferred from circumstantial evidence. Grimmer had threats from Georgia Inman that she would bring any claims possible against the firm and the attorneys. A few weeks before applying for the renewal policy, the Wyoming court issued a ruling in favor of Georgia. That ruling was issued 5 days after the prior policy expired. Grimmer knew, or should have known, that he and his firm needed insurance coverage. However, when he applied for that insurance coverage and asked for it to apply retroactively, he did not mention any of these material circumstances to Travelers. He knew, or at least he should have known, that Travelers was concerned about this kind of information when they asked for a separate letter. Nonetheless, he did not disclose the information. Georgia made complaints relating to Grimmer Davis's ongoing representation of Patterson, the alleged resulting damages to assets owned by a trust to which Georgia is a beneficiary, and their obligations to her as a former client. The defendants, the lawyers, contend that Georgia's claims against Grimmer Davis can simply be attributed to Georgia's confusion as to the firm's names. She did admit to some confusion as to the relationship of the two firms, but she also made clear she was seeking disqualification of Grimmer, Davis, and both firms specifically. She repeatedly referred to firms in the plural, as did the courts. There is no genuine dispute as to whether Georgia threatened claims against Grimmer Davis and its members relating to conduct that occurred after she was represented by G&A. Under the terms of the policy, a claim is a demand for money or services against an insured for a wrongful act. Georgia claimed that the damages to the trust was in March of 2018, again after Grimmer Davis was formed. Georgia repeatedly made such claims stemming from Grimmer Davis's representation of Patterson in 2018 after Grimmer Davis was formed and representing Patterson. Grimmer does not allege that he was unaware of Georgia's claims and assertions. The special master's report and the Wyoming court order clearly dealt with both firms. Even if Georgia's claims against Grimmer Davis had proved to be unmeritorious, it was clear that she intended to bring them, and bring them against Grimmer Davis, Grimmer, and Davis. It does not matter whether she alleged a valid claim, only that she was threatening to bring claims. Grimmer either knew or should have known the information he provided to Travelers was false. Grimmer's representations to Travelers were material because Travelers relied on them in issuing the renewal policy, and they contributed to the loss. A fact is material to the risk assumed by an insurance company if reasonable insurers would regard the fact as one which substantially increases the chance that the risk insured against will happen, and therefore would reject the application. If a fact would naturally influence the insurer's judgment in making the contract, estimating the degree or character of the risk, or in fixing the rate of insurance, then it is material. Defendants present no evidence to dispute Travelers' position on reliance or materiality, and they do not assert a material disputed fact that would prevent the court from entering summary judgment. Even if Georgia Inman erroneously made claims against Davis, Grimmer Davis, and Davis in their roles in the Grimmer Davis should have disclosed the existence of those claims to Travelers when it was pursuing the renewal policy. Those claims were material, and Travelers relied on Grimmer Davis's assertion that there were no such claims in issuing the policy renewal. Grimmer knew of the claims and did not disclose them. The court therefore concluded that defendants, Grimmer Davis, Grimmer, and Davis, made misrepresentations to Travelers. Travelers relied on those misrepresentations, and those misrepresentations were material to Travelers' decision to provide insurance. Accordingly, the court concluded that Travelers was entitled to rescind the policy under Utah law. The court further declared that the policy was void, and Travelers has no duty to defend or indemnify the defendants under the policy. The motion of travelers for summary judgment was granted. In my opinion, a lawyer should know that insurance is a contract of utmost good faith, where neither party may do anything to deprive the other of the benefits of the contract. In this case, a lawyer not only failed to act in good faith when applying for malpractice insurance, he acted badly by misrepresenting to the insurer that he knew of no potential action against him or his firms when, in fact, he had been so advised by Georgia and her counsel and by orders of 2 different courts. Rescission was the only appropriate action available to the travelers. This video was adapted from my blog, Zalma on Insurance, and the recent decision of the Utah courts. It is available at www.zalma.com/blog and can also be viewed on Rumble and on YouTube. If you found this video useful, please pass it on to your colleagues. It's free, and please also subscribe to my YouTube channel, my Rumble channel, my blog, my Substack publications, and my files on locals.com. Thank you for your attention.